Hello everyone. Before starting void agreement, I'm going to take the meaning of void agreement. So, an agreement not enforceable by law is said to be void. A void agreement does not give rise to any legal consequences and is void ab initio. What is void ab initio? The Latin word, which clearly says those agreement which from the beginning, it is void. It cannot be enforced by any law. So, what void agreements include? We have 6 points under it. So, and we have different sections. So, let's start with the section 11. Agreement by a minor or a person of unsound mind. That comes under section 11. Agreements made under a bilateral mistake of fact material to the agreement. Section 20. Agreements made without consideration. Section 25. Agreement of which the consideration or object is unlawful. Section 23. Agreement of which the consideration or object is unlawful in part and the illegal part cannot be separated from the legal part. That comes into section 24. So, next one. Now, the to be void by the Indian Contract Act R, which cover our last point, agreement in restraint of marriage. Section 26. Agreement in restraint of trade. Section 27. Agreement in restraint of legal proceedings. Agreements, the meaning of which is uncertain. Agreements by way of wager. Section 30. Agreement contingent on impossible events. Section 36. Agreements to do impossible act. Section 56. So, we'll cover each agreements. We'll cover each sections in detail in coming slides. So let's discuss agreements in restraint of marriage. According to section 26 of the Contract Act, every agreement in restraint of the marriage of any person other than a minor is void. You cannot enforce anyone, you cannot restrain any person on certain agreements. Agreements, the meaning of which is not certain or capable of being made certain, are void. The term of the agreement must be clear, complete, and certain to be enforceable. Let's take an example. A agrees to sell to B 100 tons of oil. There is nothing whatever to show what kind of oil was intended. The agreement is void for uncertainty. Now, wagering agreement. Wagering agreements are betting agreements. For example, where A and B mutually agree that if it rains today, A will pay B rupees 1000, and if it does not rain, B will pay A rupees 1000 is a wagering agreement. Now, essentials of a wagering agreement. First one is uncertain event. What is uncertain event? An event may be uncertain either because it is yet to take place or it might have already happened, but the parties are not aware of its result. Mutual chances of gain or lose. So each party should stand to win or lose. If either of the parties may win but cannot lose, it is not a wagering agreement. Neither party has control over the event. No other interest in the event. Promise to pay or money's worth. Agreement by way of wager are void. Now, distinction between wagering agreement and insurance contract. Meaning, an agreement between two persons is a wagering agreement if money or money's worth is payable by one person to another on the happening or non-happening of an uncertain event. Insurance contract is a contract to compensate the loss caused to be insured. Legal effect. It is valid, it is void. Wagering agreement is void, insurance agreement is valid. Contract of indemnity. A wagering agreement is not a contract of indemnity, it is a contract of indemnity. Now, next one is the nature of contract. A wagering agreement is not the contract of uber me fide, What is uber fide? It's an utmost good faith. But an insurance contract is a contract of uber fide. Insurable interest. In a wagering agreement, parties do not have any insurable interest. But in an insurance contract, the insured has the insurable interest in the property insured. Amount payable. In a wagering agreement, the amount payable is fixed. But in insurance contract, the amount payable is not fixed, but depends upon the loss incurred, the amount insured, and other terms and conditions of the contract. Now, use of scientific calculation. To find out the amount, we don't require to use scientific calculation in case of wagering agreement, but in case of insurance contract, we need to have a scientific calculation which is done by actuarial scientist. Now, the purpose is to make a profit, but the purpose is to compensate the loss which may occur in future in case of insurance contract. Public interest. There is no public interest in a wagering agreement, but yeah, surely in insurance contract, we do have a public interest that is for a good for